He just wants to make a brief contribution to the discussion we're having. La,
Yes, sir.
good morning.
Morning, sir.
Yes. We'd like to listen to you. What are your thoughts on what thoughts do you want to share on the discussion we're just having with lawyer Eduji?
You covered a lot of ground, and I was just wondering whether there's anything more you would want me to comment on specifically. But you touched on so many subjects from the Supreme Court to Yoko and all that. So I just want to know specifically what you want.
Okay. I am guessing the big matter is the matter of the CJ and the decision that was made on her and that affidavit and the application for injunction. You agree with the court generally?
Absolutely. Injunctions are equitable remedies. Even in private law, as between two private individuals, injunctions are not granted automatically. There are core principles that are always govern the grant or refusal. And more especially in this case where the plaintiff is not a private individual but a person holding or previously holding a public office and is purely one of the public law remedies, that is a constitutional right that is being invoked in a constitutional litigation. The court will even be more careful in evaluating such an application. Here we are having a president acting in accordance with the constitutional provision to carry out only what is an executive function conferred by the Constitution on the president. And for a plaintiff to seek an interim order to restrain the president or any other person appointed by the president in pursuance of those constitutional provisions, Article 146, such a plaintiff carried a very onerous duty of convincing the court to so intervene. And I think that the plaintiff was not convincing enough.
Was not convincing enough.
That is it. For instance, listening to my younger brother, Education, he hit the nail right on the head. Injunctions are not standalone actions. They are founded on the substantive action. So remember that a writ invoking the original jurisdiction of the Supreme Court, seeking certain remedies, including declaration, etc. So in assessing the injunction application, which is an interim relief, the Supreme Court will examine the substantive action to see whether the action will have any merit at all. Although, at this stage, the Supreme Court is not supposed to go into the merit of the substantive action itself. On the face of it, the prima facie, they can fit back. But then, the Supreme Court or any court reviewing an injunction application will not have to determine a prima facie case on the basis of the substantive action. But at least the court must ask itself whether the plaintiff, the applicant, has been able to establish a claim for an action that is sustainable in law. As indicated, this prima facie determination by the president of a petition is one that is not communicated in any reasoned decision or judgment. My understanding is that the Chief Justice and her lawyers are urging on the court that she was not furnished with the reason for the prima facie determination, or in other words, that there were at least more than one petition, and the president, in consultation with the Council of State, in coming to the prima facie determination, failed to indicate whether on all three petitions a prima facie case was found, or prima facie case was found on one and not the other. I think that this is a matter of splitting hairs, because if three petitions were presented to the president, and the president, after consulting the Council of State, comes to a decision that a prima facie case has been made, without pointing exactly to which one of them in which a prima facie case was found, it will go without saying that a prima facie case was found in all. Otherwise, the president would have specifically indicated a particular petition that gave rise to the prima facie determination. By not specifying which of them, it goes without saying that in all three cases, such a prima facie determination was made. And yet this forms the basis of one of the substantive reliefs that the Injunction is seeking, in my view. Such a case is weak, and therefore may not convene a court to grant an interim relief. The other one having to do with the right to be heard in public, when the Constitution provides expressly that such a hearing should be in camera. Clearly, it is not a private right conferred on the particular superior court judge or public officer facing a petition for removal under Article 146. It has been interpreted as Edudy indicated in decided cases that the intention behind that provision is to safeguard the judicial independence and integrity of the court or the judiciary, for that matter. So that although we have what we call a statutory waiver or class protection provisions in some statutes, where the class that the law seeks to protect or an individual belonging to that class may choose to waive that protection. In this case, it is not a personal right of protection given to a superior court judge under Article 146 to decide with that protection under the law. It is one intended to protect that office. That is to say, the judiciary as a whole, and not the particular judge facing a disciplinary action. And therefore, it is not available as a right to be claimed by a plaintiff, the Chief Justice for that matter, that the in-camera hearing, after all, it is for my protection, and therefore I can decide to waive it. It is not a private law protection conferred by the Constitution as indicated. Clearly, it is for the protection of that public office or institution, and no individual within that class is entitled to claim a right of a waiver. I'm sure that the argument that the plaintiff and her lawyers are trying to urge, and which they will be urging on the court in the substantive matter, is this argument of a class protection provision that may be contained in some statutes that an individual within the class could elect to waive. That's private law kind of right to waive a class protection clause or provision. It's not applicable in this case. These are just a few of my observations and additions to what my friend Edwige has already eloquently enunciated.
And I guess you're also paying attention to the matter involving Ashanti Regional Chairman of the New Patriotic Party, Chairman Wontumi. He currently has a bill of 50 million, too short is to be justified.
Yes.
A difficult hurdle to climb?
Nothing is difficult for Chairman Wontumi.
Nothing is difficult for Chairman Wontumi?
Not at all. Remember that it's a movement like apartheid. It takes a movement so strong as apartheid.
So the members of the movement should be able to rally themselves and find it.
That is it. In fact, all bills carry some conditions, and the bill conditions in most of the cases are commensurate with the gravity of the offense or the matter in issue. I believe the payment that was made was of approximate quantum, the 50 million. And in most cases, courts even go beyond the subject matter. But in this case, the bill condition was pegged exactly at the amount of money that is involved. And so I think it's fair.
Because this is a bail condition being given by, I believe, Yoko, not the court.
Well, Yoko will not have a final say in all this. His lawyers know what to do.
Okay.
They may go to court to seek amelioration of this condition. The court may even enhance it to their disappointment and make it even more stringent or relax it. But Yoko won't have a final say. But I think that Yoko, as an investigative body, has what it takes to at least set bail conditions.
So there are no guarantees that even if they challenge this in court, it will be automatically reduced. It could be worse for them.
Exactly so, because you know the courts in a lot of cases defer to the law enforcement. That is the prosecution. Okay? And it is so automatic that the court will just look the applicant favorably and reduce the bail condition. So,
I see. Are you a member of the movement?
that movement is so strong, like apartheid.
Are you a member?
I wish. How I wish.
How you wish you were a member?
It's a very powerful group, and there's a lot of cash. And so, how I wish I was part of that movement then. But now, that uncharted waters that I have to caution myself.
Lawyer, thank you. Thank you very much for speaking to us.
You're welcome. And good morning to my learned friend, the lawyer.
Oh, okay. Thank you. Lawyer David Ametepe is a private legal practitioner. SM, it says I should extend good morning to you.